Now this is the ruling. Now, plea in this matter came up on 9th December 2019. The accused present pleaded not guilty and pleas of not guilty were entered respectively. It was at that stage that the prosecution indicated that they were only opposed to the release of accused one in both ACC 31 and 32 of 2019 on bail. They were not opposed to the release of the rest of the accused persons on bond, but requested the court to consider imposing some conditions which they laid bare before the court. On the same date, I dealt with issues such as those of health of accused, and hence I will not consider the same in this ruling. The parties were allowed to canvass their respective positions on the matter of admission to bail for accused one. They relied on several authorities to assist or persuade the court in either admitting accused one to bail terms or not. As much as I may not cite each case, I will only rely on the relevant pronunciations made in the respective cases in order to arrive at a conclusion and make a finding thereon. In opposition to bail in respect of accused one, the prosecution relied on the affidavit of Simon Chepka, a forensic investigator with the Ethics and Anti-Corruption Commission herein after EACC. The affidavit was sworn and filed on the 9th of December 2019. Among the grounds put forth by the prosecution were that if accused one is released on bail, there was a high likelihood that he will interfere with witnesses who are his junior employees, as he is the chief executive officer of the Nairobi City County, and that he had used his position to threaten the county executive committee members from recording their statements at the EACC. Hence, releasing him would interfere with investigations. That on 6th of September 2019, he attempted to escape from lawful custody. On 12th March 1998, he was convicted in criminal case number 1727 of 1996 and criminal case number 675 of 1997 and sentenced to Kenya shillings 500,000 and 200,000 respectively in default to serve 6 months in jail for each count, sentences to run consecutively. This was because of failure to appear in court. He was then committed to jail at Shimola Tewa, where he sought for treatment at the Coast General Provincial Hospital, where he escaped from lawful custody. The accused one still has a pending criminal case number 275 of 2011, where he was granted anticipatory bail via Mombasa criminal application number 244 of 2001, but declined to present himself before court. A warrant of arrest was issued by the CM's Court Mombasa in criminal case number 275 of 2001. That the offenses facing accused are grave and serious, and it will be in the public interest to deny bail. It was also submitted by prosecution that the signal submitted by accused one to court referred to case number 80 of 2001, where A1 sought revision for the reduction of sentence of 6 months for the consecutive sentences in criminal case numbers 1727 of 1996 and 675 of 1997. And it was after case number 675 that the accused absconded. That what was called a signal did not anywhere talk about success of an appeal and reduction of sentence. Further, that the prosecution had not been shown the alleged proceedings in criminal case number 8635 of 2000, and that a certificate of good conduct was not evidence of court proceedings. That EACC forms for clearance were self-declaratory. The prosecution further argued that circumstances of accused 1 were different from those of other accused, that there was no discrimination against accused 1 as alleged. Mr. Miller for accused 1, who teamed up with several other counsel, raised objections to the application by the prosecution on denial of bail in respect of accused 1. They argued that there were no annexures or any factual basis on the allegations laid against accused 1 by the affidavit of Simon Chepka of the EACC. This was the general argument on all fronts, including that of interference with witnesses, that CEC members were summoned by the EACC and had recorded their statements on 15th November 2019, whereas accused 1 recorded his on 30th August 2019 at 10 a.m. That accused 1 was alive to lay down procedures and had decided to follow the law in order to address his grievances against senior EACC officers by filing constitutional petition number 34 of 2019, which is still pending in the High Court. On the issue of fleeing out of jurisdiction, it was argued on behalf of accused 1 that he was arrested within 2 hours of the DPP's arrest order and that he had not been notified, and a question was posed as to how one would run away using a public highway. The accused was unfairly treated during his arrest and was assaulted. Further, accused 1 was cleared to run for a parliamentary seat and was Member of Parliament for Makadara when criminal case number 8635 of 2000 was going on in Kibera. The defense produced a signal in respect of an appeal number 80 of 2001 by Oguk J, who is now late, which they argued had not been appealed against, that no warrants of arrest had been attached, that there were chances to arrest accused 1, one being his visit to Shimolatewa in 2011, and they questioned why he was not arrested then. That accused 1 was not a dangerous person. He had been cleared to run for parliamentary seat as an MP for the Senate and for Governor of Nairobi. They presented a police clearance certificate, otherwise known as Certificate of Good Conduct, that he was also cleared by the EACC, which documents they cannot renege from. Further, accused 1 was honored with the honor of Elder of Burning Spear, EBS, and was also a member of the International Police Association. They handed over a respective identification and a badge to the court, and that he was also a holder of an award of the Good Deeds Ambassador by the UN. It was also argued that disputes as to tenders allowed office holders to continue holding office till their culpability was decided by a court after a trial. That there being no substantive holder of the Deputy Governor's office in Nairobi, charging of accused 1 was to bar him from office, and this court was requested to balance public interest on how people of Nairobi will be served. With all due respect to counsel on this aspect, the issue of lack of a substantive governor of the county of Nairobi has been a subject in the public domain, which I take judicial notice of due to its notoriety. However, be that as it may, this court has not been clothed with the necessary jurisdiction to give it the necessary authority to even touch on the said subject raised in submissions, and I leave that issue at that. The court was also referred to the cases of Professor Swazuri in Criminal Revision number 13 of 2018, that of Amritral Jivraj Shah versus Republic in Miscellaneous Criminal Application number 35 of 1984, Republic versus Cyrus Mwangangi Kimumu 2016 EKLR. They also complained that all exhibits tendered were copies and illegible. The court was urged to rely on Article 180 and 181 of the Constitution and several other cases, and that it should be found that the DPP misused its constitutional powers and discriminated against the accused. Further, that the court had also, at more or less, settled terms of bail, and several figures were floated to the court to consider. If a company was accused, the court was urged not to impose punitive terms, as the representatives of the company were also accused within the same charges. Some counsel acceded to any conditions to be given out by the court, but urged reasonability due to the presumption of innocence. Some accused were said not to be having passports. I have considered all arguments by all parties that made presentations before me. First, I will address the documents placed before me in order to answer the question as to whether or not A1 should be admitted to bail. On the affidavit of the prosecution, I said this: an affidavit is a source of evidence. It lays bare before a court of law what the deponent wants the court to believe and rely on. Evidence means something including testimony, documents, and tangible objects that tends to prove or disprove the existence of an alleged fact. Anything presented to the senses and offered to prove the existence or non-existence of a fact. In order to rely on such evidence, it has to be very clear. Annexures SPC 2, SPC 6, SPC 9 were not legible. The court could not discern what kind of evidence was being relied on by the prosecution. The prosecution is advised that any such evidence must meet the threshold of the good and best evidence rule. In arriving at a proper conclusion and decision, there are several tools available to this court to use. The tools available, among others, include the laws, policy, pronouncements of the court. On law, the Constitution of Kenya at Article 49(1)(h) provides that, I quote, an accused person has the right to be released on bond or bail on reasonable conditions, pending a charge or trial, unless there are compelling reasons not to be released. Article 49(1)(h) is operationalized by Section 123A of the CPC Cap 75 laws of Kenya, which requires the court to have regard to all the prevailing circumstances, and in particular, the nature and seriousness of the offense, the character, antecedents, associations, and community ties, the defendant's record in respect of fulfillment of obligations under previous grants of bail, and the strength of his having committed the offense. Also, whether having been previously granted bail, failed to surrender to custody, and if released on bail, whether or not subject to conditions, it is likely that he would fail to surrender to custody. All the above grounds were argued by the prosecution and responded to by the defense in relation to accused one. There is also guidance given under policy and guidelines. On the nature of charges, it's assumed that where the charges are serious and punishment heavy, there are more probabilities and incentives for the accused to abscond. Where there is a strong prosecution case, it may be justified to subject an accused person to pretrial detention. Where evidence against the accused is strong. Let me read that. Where there is a strong prosecution case, it may be justifiable to subject an accused to pretrial detention where evidence against the accused is strong. However, this is available where all prosecution witnesses have testified. On the likelihood of interference with witnesses, bond will only be denied if there is strong evidence of the likelihood of interference with witnesses which is not rebuttable, and the court is not able to impose conditions to the bail or bond to prevent such interference. On the issue of flight risk, it must be demonstrated that the accused has no permanent abode and may therefore fail to attend court if granted bail or bond. This is especially applicable to foreigners whose host countries do not have extradition treaties with Kenya. There is also the aspect argued of leading supporters to the EACC who cause destruction. Pretrial detention may be necessary to preserve public order, where it is demonstrated that the public response is such that if the accused is released, it's likely to lead to public disturbance. Besides policy guidelines, the court is guided by pronouncements of superior courts, whose pronouncements on matters of bail and bond are binding on this court due to the nature of their binding, due to the principle of their binding nature and respect for hierarchy of courts. Several authorities were cited. Be that as it may, this court is aware that some of its findings on bail bond, especially on requirements on cash bail to be deposited in court and security of bond terms, has been interfered with downwards, and there seems to be some kind of uniformity which the court will apply when it arrives at that stage. It was argued that the circumstances facing A1 would be the same as the decision in revision number 13 of 2018, that is Professor Mohammed Swazuri and 6 others versus the Republic, among others, and that most authorities cited by the prosecution were in respect of murder and robbery with violence. The most recent cases that are related to this matter are that of Moses Kasaine Lenol Kulal versus DPP 2019 EKLR Nairobi, and Ferdinand Ndungu Waititu Babayao and 12 others versus Republic 2019 EKLR Nairobi. At paragraph 60 of the Lenol Kulal case, Mumbi Ngugi J found as follows, and I quote, "I accordingly decline to exercise powers of revision over the decision of the trial court in this matter. The term set for the applicant's access to his office shall remain in force for the duration of his trial. I need not add that it is in the public interest and the interest of the applicant that the case against the applicant in ACC number 3 of 2019 is proceeded with expeditiously." W. Ngenye Masharia J in the Waititu case, after considering the application before her concerning barring the first applicant from office, found, and I quote, "In the premises, I find no irregularities, impropriety, illegality, or incorrectness in the order of the learned trial magistrate in directing the first applicant not to set foot in the offices of the county government of Kiambu whilst the trial is ongoing, save for the window accorded by this court to go and collect his personal belongings." You can see paragraph 52 of that particular authority. In the same authority at paragraph 8, the same judge also found as follows, and I quote, "Having warned myself, bearing in mind the presumption of innocence, I find in regards to the first applicant, the amount of Kenya shillings 15 million, cash bail or bond of 30 million with a surety of similar amount is appropriate, more so in view of my observation regarding the reasons the conditions to grant the bail were touched. In arriving at appropriate bail terms, I have considered all the charges, and in particular the charges facing each accused person, the roles played by each accused as alleged in the charges, the nature of the offenses, and the amounts involved. More so, I have taken into consideration that the purpose of bail bond principally is to give such terms in order to secure the attendance of court wherever accused is required. I've also considered the aspect that denial of bail should be the last resort. Before I consider whether or not to grant bail terms to accused one, there is one aspect of the trial raised by Mr. Nyamodi that must be addressed. That is the aspect of disclosure. There were presentations by learned counsel on this issue, especially on the requirement of disclosure count by count. The court was informed from the bar that the High Court in ACEC Criminal Revision number 42 of 2019 stated the requirement and that there is a constitutional application within the application for review to the Chief Justice to empanel a bench of 3 judges to hear the constitutional application. My order has not been set aside. In the case law of Society of Kenya versus AG and Central Organization of Trade Unions, the Supreme Court in petition number 4 of 2019 at paragraph 91 gave directions on what a judicial officer should do on learning of an appeal referred on the same subject matter before it. I'm aware that the above mentioned revision is pending before the High Court, and I take judicial notice of it. The determination therein may as well have a bearing on the requirement of disclosure count by count, which this court has interest in. The court is proceeding on leave within a week. The said information the information is that the matter is coming up before the Honorable Judge on 17th of December 2019. In fixing this matter for the next court proceedings, I will consider the above situation. In attempt to rebut evidence by the prosecution, accused one produced a signal, a certificate of good conduct, identification showing him as a member of the International Police Association, and also informed the court that he had been honored with the award of the Elder of the Burning Spear, and that accused one was an holder of an award of Good Deeds Ambassador by the UN. The respective agencies that either gave him the clearance certificate or the awards know better the reasons why they gave him the clearance certificates or honored him with the awards. Since no such evidence was placed before the court was denied an opportunity to make a finding on the same, as courts only give pronouncements based on evidence. After having considered all the material placed before me, I am of the considered opinion that all accused are hereby admitted to bail terms. These bail terms must be adhered to the letter. Any violation shall lead to cancellation of the bail terms. In terms of companies charged, I have considered that they are legal persons who cannot be sent to jail. Hence, the bail terms will be a consolidation to be met by their legal representative. To be very clear, the bond terms on the legal representative alone will suffice for the limited liability companies. Now, the accused are admitted to the following bond terms. Accused 1 to a bond of 30 million with one surety of similar amount and a cash bail of Kenya shillings 15 million. Accused 2, 3, 4, 5, 6, 7, 8, and 9 to a bond of Kenya shillings 3 million with one surety of similar amount or to a cash bail of Kenya shillings 3 million. For accused 10, 11, 12, 13, 14, 15, 16, and 17 to a bond of Kenya shillings 30 million with one surety of similar amount or a cash bail of Kenya shillings 10 million. The accused who have not taken plea will only have their bonds processed after plea. All parties in the case, including but not limited to the office of the DPP, the EACC, the accused, are hereby prohibited from commenting on this case on social media in whatsoever manner.